Hey, good morning. I hope everybody's having a good morning or afternoon, depending on where you are in the world. Yeah, so I wanted to jump on here and talk a little bit about the simplicity of things because I think there is a lot of people who are new to this understanding of the what many people call the straw man, and they're trying to wrap their head around how the whole mechanism actually works. And for me, the most important thing is definitions, 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 because that is what really defines everything that we are trying to say to another party, especially when it's all under contract or agreement or implied contract or implied agreement. It's definitely behooves us all to study the definitions. So again, there's been a mass awakening, a lot of people over the years realizing that there's a legal fiction. They call it a straw man. A lot of people call it a straw man. That the governments of the world somehow seem to create or control, and that they have a trust set up. And a lot of people think that they have millions of dollars in this trust, and they can just access it like a bank account, and so on and so forth. So there's a lot of confusion. There's a lot of misunderstanding based off of 12 years of experience uh, and application, meaning in the trenches, not just reading this stuff and telling people how they should use it. We don't do that. Everything that we've done or talk about, we do ourselves. We don't preach remedy for anybody. We're not doing that. You want remedy? There's plenty of people selling that online or touting that there is remedy. To have remedy, you have to have an injury. So you got to prove an injury. That's a legal concept. We don't do that. We've helped many people. We just don't call it remedy. Relief, possibly, or release, which we'd rather say, right? Release, because release is you're releasing. It's a new contract. Relief means that you are willingly abiding. So we don't get that from what we do. We just don't get the relief thing. So anyway, we're going to talk about the structure of things. I think people are really confused. Let's start with the birth, right? Your birth, you're registered, or there's a registration. The government then creates another organization out of that, which is where the birth certificate comes from. First, you have the certificate of live birth, which is the registration or the application. Remember, there's an application first for the registration, and that's usually what you see a part of on your certificate of live birth. You see part of that application where there's an informant, right? So if there's an informant, then that means there's an investigation. Somebody's giving information. Your footprints are on there, right? Your first landmarks to make sure that you land in the fiction first, so they can create a dead fictional entity, which they do. So the government owns that entity. The government created it. There's a lot of people out there trying to claim it, trying to, copyright, trademark the name, and all good. I'm not saying there's anything wrong with that. The reason, in my opinion, that those things work is because the government has legal title to that organization. It's a trust. So if it's a trust, that means the title is split in half. That means someone has beneficial title or equitable title, it's called, and someone has legal title. Trustee holds legal title, beneficiary holds equitable title. That's just how trusts work. So we've seen enough being in court and stuff and bringing up the trustee and the executor position and all. We've seen enough judges' reactions. We've seen them get nervous. We've seen them leave the bench. We've seen several different responses, reactions, cases that just got nolle pros, nolle prosecute, which means we no longer prosecute, because if the government's holding the legal title, they're the legal owners. They're supposed to be dealing with all the legal stuff that happens to that organization. But they flip it around and they make you the legal title holder. Okay. So this is where people are getting confused. In my opinion, in my experience, I think this is where people get confused. The government should retain legal title to that organization. They should be responsible for handling the taxes, the bills, all of that stuff. So I don't want to claim that. I don't want legal title to that thing. I'm a man of God. I can't own anything. And I certainly can't operate that organization. So what I always do is I put my notice of interest in, I put my claim of beneficial interest where I become the creditor of that organization, which means I get to benefit from it, but I'm not the owner of it. The legal owner is the government. They own it. I'm just a beneficial interest holder. So that's pretty much how I believe it really lays out. And it's a lot easier to see it in that way than to get lost in all the muck and mire of all these other processes and procedures that people are doing. Like secured party creditor, that's a big one. Not saying it doesn't work, but what are you actually doing in that transaction? You're saying you're the creditor, you're the beneficial interest holder. You have an interest as a creditor, you have an interest. So there's a beneficial interest. It's all you're doing. You're just doing it in the Uniform Commercial Code, which is federal law and state. They've codified it in the state as well. Okay. So, but at the end of the day, that's all you're doing. You don't need UCC to do that. It's law. I mean, that's equity. That's law. It's saying, hey, I found some abandoned property here. Doesn't matter about if it's your name or not your name. It's abandoned property. I'm going to claim it as the beneficial interest holder, and I see that the owner is the government because I've got a certificate here that says they're the owner. So here's an interest, certificate of interest. That's it. It's not that difficult. So I only use, I used to use affidavits. I don't use that anymore. I use asseverations, notices, and orders from the general executor position. A lot of people don't like the general executor position. They think that that's wrong. Some people say that the government is the executor. Well, true, they are, but there can be 50 executors. It doesn't have to be one. Okay, the general executor is general to the entire organization, so it can appoint 50 executors if it wants to get the job done. All right. So it's all about understanding this relationship between you, it, and the government. The government's another it that created another it out of you, which is an organization, and they own it. They own it, and they should own it. They're the legal title holders. They're the ones that are in charge of all the legalities of that organization, which is why if you go into a courtroom and you immediately appoint the prosecutor, the trustee, they'll start getting squirmy. Okay. And a lot of people get caught up on that. They get caught up when they go into court because they don't know what to follow up with. They might know that part, but if anybody is going to go into court, you better know how to think on your feet and respond and listen. I see a lot of people go into court, they come out with these stories, and I'm like, but you just told me the judge told you what to do, and they're like, well, what do you mean? Well, you didn't listen to it. The judge said this, that, or the other, and you just ran right over him. Like you didn't catch you didn't catch the secret that he was throwing to you. It's like I had one guy that we did everything for his traffic violation where he got arrested and all that stuff. And he was in court, and he went in and he said, well, the judge said, that we notified the wrong person, because I don't put anything into the court. We do everything behind the scenes. And he said, the judge said, oh, well, who did you send it to? And he said, well, the chief judge of the courthouse, because there was no judge appointed to this case yet. And the judge literally told him, she goes, that's not who you sent it to. You need to notify the prosecutor. So he came back to me and told me the story. And he's like, yeah, man, I don't think, I think they railroaded me. She said it didn't go to the right person and that the prosecutor needs to receive it. And I'm like, but she told you what to do. She told you who to send it to. So we did that. And lo and behold, the next court hearing, everything was dismissed. Well, they nolle pros, which means, we no longer prosecute. So again, it's all about this relationship. And most judges will not take the position of trustee. They will recuse themselves. I found, I forget which state it was, but I believe it's probably in all the bar rules. But you could look up bar rules for the particular state. And I forget which state it was, but I looked, it might have even been Florida. I can't remember. We looked it up and it said right in there, one of the main rules is that a judge cannot be a trustee. They're not allowed to be. So they're going to, if they're, part of the bar association, which most of them are, they're not going to take that trustee position. They're going to disclaim that. And that's fine. We've recused judges that way by continually appointing them trustee, and they'll recuse themselves. So they don't want that. Well, the judge can't take the trustee position. The judge is your mediator. When you're in a trust situation and you've pulled the whole thing into equity, the judge is merely a mediator and is a facilitator. They're not a judge. They don't have the authority to judge. Now, they'll try it. They'll threaten you. They'll intimidate you. They'll do everything they can to try to destroy that idea that or the idea of trust, and that it. They'll try to have you, tested for competency, all that stuff, because they're trying to hide this in these courtrooms, which is why I particularly do not go into these courtrooms and bring this stuff up. If I'm dragged in there, meaning they're going to have a hearing and I have to show up, because if I don't, they're going to joinder me to the thing, right? And they're going to put this judgment on my thing. I want to make sure that I am going to show up, and yes, I will say who I am and what I'm there to do, and that there is no authority for them to move. And we've done this plenty of times. And again, half the time we don't even have to go to court because we can abate everything right from the start. But getting back to the main point, again, it's a simple construct. The government holds legal title. You hold equitable title. Okay. So let me read a question here. Notice an order, special executor backs off, can't profit off a negative instrument, so turn it around. No, I mean, I'm not saying anybody backs off. You can't determine what the other side is going to. I'm saying we've seen it, but you can't determine what the other side's going to do. Technically, lawfully, that's correct. But remember, these guys are going to push the envelope because they know, at the end of the day, they're like, well, who are you going to get to enforce this, right? They're going to push that. So it all depends on the person on the other side. I don't do affidavits anymore. I only do asseveration. I've already took my vows to God. I can no longer swear oaths. I can't get notary jurats, anything like that. I use asseveration only, which means with God as my witness. And I stand on those principles. I mean, a lot of this is knowing the language so well that they know you know. And by listening to what they say to you and being able to counter them real quick in peace and in honor and in contract and all that, they know you know. That's key, because somebody that's just throwing paper in there and it's going to go, oh, well, we're free because we gave you paper, they're going to run right over you eventually, because eventually you're going to have to speak to them on what it is the paper says. And I'll probably say this in every video because it's so important to study the language, to know the language, and to know how to interact. So think about this. If the government is holding legal title and you don't have a right to operate your name ever, then how would you react to something that comes in that name? Be it a police officer, be it a letter in the mail from the IRS, whatever. How would you react? If you don't own it, you don't have a right to react or respond. You don't have a right to administrate that thing, period. I'm sorry. I don't have an attorney. I can't administrate any of it. I don't know who you're talking to. I don't have any right to that. I'm not the legal title holder. That's all they're trying to get you to do, is be the trustee so you can authorize the charge against yourself. Then, yes, you become the surety. Okay, if you authorize the charge, you then become the surety. You're the underwriter. You're writing under the policy. You're securing it. So that's all this is. It's all it is at the end of the day. And it's a lot easier than we think in terms of structure. So, you really don't have to, I don't want to say you don't have to. It's a struggle to learn this mechanism, right? But it's easier than we think. Trust, 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 trust. It's all about the trust and who's holding, and it's about your life. How do you react to this trust situation? People are so used to just responding, fighting, arguing. This is why I don't get into the fight thing. I'm not fighting and arguing with these people. I don't have to. I'm not the one with the legal title. It's against the law for me to sign for that thing. It's against the law. It's been against the law from birth. That's why your mother and father, or your mother or whomever, usually, at least in the United States of America, the certificate of live birth has one of them listed as an informant, because somebody's saying, hey, there's some laws being broken here. I'm reporting this as an investigation. So from that point forward, every time you answer to that name when a government agency or a contracted agency from the government contacts you, you are breaking the law, because you are administrating this organization that you don't have legal title to administrate. You're only the beneficiary. So keep it simple. Keep it simple. I get something legal in the mail, or friends of mine get something legal in the mail. First thing we do is abate it. Don't know who you're talking to. Ain't us. Go through the whole letter. Hey, open the mail by accident. Apologize. Don't know who you are. Don't know who you're looking for. No one here exists by that name. We looked that name up on the internet. There's hundreds of them. Don't know who it is. If you'd like to clarify and correct, your presentment and serve it to the proper party, that would be great. We appreciate that. Thank you for your time and energy and service to our community, if they're, a government agency. And then I just put a little signature on it, no name. I don't type a name under it. I don't put a name. Just let them know that, hey, I'm an executor, and this landed near our location and was abandoned, and we don't know who sent it. But just letting you know, we apologize for opening it. If it was meant for us, just correct everything. That usually stops 90% of things, because they can't proceed without perfecting the proper information on the claim. I have to have the proper party. And if it's denied right from the start and you don't agree to it, they usually drop things because they can't proceed. Or I shouldn't say they drop it. They'll keep trying. But if you keep abating it over and over again and sending it back, instead of Title 20 this and Article this of the Constitution and my rights, as soon as you do that, you just agree to everything they said. It doesn't matter what little statutes and stuff you quote and Constitution and law. It doesn't matter. You just agreed. You agreed to get into a battle with them and defend this organization that you don't have a right to defend. So we need to stop doing that. It's a lot easier that way. And I think that's the big message, is to stop reacting. A response is okay, but a reaction usually gets you in trouble. So again, let's talk about the structure. It's very, very simple. Government's a trustee. Okay, they hold the name, they hold the accounts, they have all the legal duties for all of it. We are the beneficiary. We have the equitable right to that, which means any proceeds and all that any distributions should be coming to us. They should be coming to us. It's that simple. It really is that simple in structure. All right. Where it gets crazy is when we start acting on this thing's behalf, whether you're fighting on its behalf or not, or showing up and saying, I am the living man, and which is, that's not bad stuff to say, but at the same time, if you're showing up and you're in defense, then, well, clearly you must be saying that you have some administrative right to this organization, because you're in here defending it like crazy. So abate, and then this is where the general executive position comes in my opinion. So you got a few things here. You could either totally disassociate and say, I'm not under anybody's laws. I don't know who you are. That's not my name. I don't belong to this. I'm done. Leave me alone. That kind of thing. Or you can have your claim, right, which is your security agreement, your power of attorney, revoking their power of attorney or any assumed power of attorney, and then saying, I'm the general executor, so I'm exonerated from any claims against the estate. I'm just here to see that the estate is wound up properly. I'm just here to see that it's being administrated properly. That's it. I'm not here to make any judgment calls or operate this thing at all. I'm here to make sure the trustees are operating this according to the trust terms. That's a powerful position. So people that poo-poo the general executor position, to me, are doing themselves a disservice, because you're at you have a firewall with that to be able to appoint another executor or administrator or trustee. They use all these terms interchangeably when you get into wills and trusts and estates. All right, a lot of it. So basically administrators. So to be the general executor is really important, in my opinion, and that's the position we've always used. So I can appoint them to do something. Now they can be an executor. Not a problem. You know, they're just another executor under the umbrella of the general executor position. So understanding wills, trusts, estates, and things like that is super important. Getting lost in statutory law, the only reason I would study, or I did and do study statutory law, is so I can see how they're operating the organization. So I can see how the other side functions. How are they operating this organization? Because that's all municipal law. That doesn't apply to me. It applies to the organization. So that's why I study statutory law, is simply to see how the other side functions, what they should be doing. But I can tell you in most things that I've done, I very, very rarely, if ever, cite a court case, a statute, anything. I don't ever touch that stuff because I'm in law. I don't need to do that. I'm in equity. I'm in law. I'm not in statutory municipal, color of law. I'm not in that. I can't agree or disagree to be part of that public body and then go in there and try to start using all their stuff. So that's kind of why I don't buy into the republic stuff either. Well, if you're republic, what happened to the original public? Why are you republicing something? Doesn't add up. Just like revenue, revenue. They have to change the venue. All right. Taking revenue, revenue. Again, relief. Look up leaf, right? L-I-E-F. That's basically saying you're willing. You're willing to accept. You're willing. I'm not willing to do anything. Release is a new contract. I'm fine with that. I like that because the only contract I have is with God. So if I'm going to do anything, I'm going to release. I'm not going to lease. All right. So again, understand the trust, understand how it's set up, understand who you are. And yes, a public record, this declaration of who you are in relation to the three departments of civil law, status, obligation, and property, is really important, in my opinion. Because without that public declaration, you really don't have anything that the public can actually, that the public legal system can see. It's got to be in their records so they can actually legally see it, so to speak. Everything else is private. So you're setting up in your declaration, you're setting up all your private stuff and who you are in relation to all of this, right? As the beneficiary, as the heir to the kingdom of heaven, you are saying, I'm the beneficiary. I have no right to administrate this. However, I have an equitable interest. Here it is. I've laid it out. Here's where I took interest equitably and as a beneficiary. Bam, 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 bam. Here's where I revoked everybody's power of attorney. All right. I'm the only one as the general executor that has power of attorney. So I can divvy that out. And that's a powerful position, in my opinion. So anyway, think of the simplicity. Stay with that. Don't get too lost. Study trust law, equity, things like that. Don't get lost in all this statutory fight garbage. Those of you that are into fighting for your rights and fighting the cabal and fighting the system, let's just look at the Emergency Banking Relief Act that amended the Trading with the Enemy Act and realized that as long as we're fighting, we're labeled an enemy, belligerent, and rebel. And in the law of war, which is what they follow, they can shut you down and do whatever they want to you. That's why fighting doesn't work. That's why they hate peace, because they know now if I'm on peaceful terms, they could still war against me. But if I'm in honor and I'm watching my P's and Q's and I'm saying, look, I'm not here to disrupt your circus. I'm just here to say that you guys are holding my property by occupying my land as a military force, and you're holding my property in trust, or I shouldn't even say my property. You're holding property in trust for my benefit. I'm just here to make you do your job according to your terms and conditions. That's all. Not here to fight with you. And if you're going to railroad me and do all that, well, I guess we'll just have to keep taking it higher and higher until somebody gets the message, right? So that, and honestly, I haven't seen a whole lot of that. The only time I see railroading is when somebody hasn't done their equity, when somebody doesn't declare who they are, when they don't have a public record, when they do go in there and start challenging jurisdiction and all this garbage. That's when I see people fail. Most of the cases that I've seen go right through smooth and have things just totally dropped is when we did equity from the start all the way through, noticed them in the background, didn't go into court and, go into all this rigmarole, fighting and arguing, and everything was smooth, and I've got testimonials of people that have done that. So I think that's really a big part of the key here, is not going in there and fighting and exposing. They're already being exposed by their own actions out in the public. Let them do that. That's their job to expose themselves. We don't need to do that. We expose behind the scenes and just say, hey, we know how this works. Let's form a little truce here. Let's talk about whose job is what and what needs to be done. And let me go on my way and everything's quiet. I'm not coming in here trying to wake the public up. That's not my job. That's their job. Okay, if they can't wake themselves up or they're not waking up, that's not my job. I'm not here to force anybody to wake up. Those that don't wake up when the time comes, they're probably going to not make it through the shift, and that's okay. That's what they chose to do. That's not my call. That's God's call. So anyhow, that's about all I got on that. Like I said, keeping it simple, keep it simple, keep it simple. Keep it simple, stupid. If you want to change the stupid word, I'm up for that. We could say, keep it simple, sweetie. All right. Anyway, I will catch you all later. And remember who you are in the trust and manage it that way and stay in honor. And that's all.